Hello, everybody. Welcome in. Let me get myself sorted out here. I'm a little bit early. I'd planned to go at 8, but I thought I would come on just a little early and kind of do some Q&As before I dive into the paperwork. So I'm sure lots of people have some questions, and I thought we could chat a little bit. Hello. And I've just got to give all of you a heads up, everybody. It's looking like pretty good word that this app is probably going to be going dark on Sunday. That's what the word on the street is. Writing your senator, House Bill 1526. Is that the judicial authority bill, the one about trying to change the jurisdiction of the courts so that they can't do preliminary injunctions? Is that it? Is that the one? We'll just, I gotta make sure that's the right one for us. Yes, okay. Federal jurisdiction. Sure. Now, I've not read the bill, everybody, but I've been watching all of the hearings that have been going on regarding judicial authority. And there's a couple of things. Actually, let me grab my Constitution here. Which one do I want? That one's in Spanish. Hold on, here's English. Here we go. So let me just give you a quick what's going on situation here, all right? So, as you know, all three of our branches of government, checks and balances, right? There's been a lot of talk about that. And rather than saying, one's more powerful than the other, they're basically like siblings and they fight a lot. Congress fights a lot with the judiciary. In fact, Congress and the judiciary are probably the two siblings that hate each other the most. Well, wait, let me take that back. I think the judiciary thinks that they're great. And that Congress is like, you're a jerk. So here's the thing about Congress. Congress was given the authority here. Let me just pull the section out for everybody. Was given the power. Let's see. Commerce, uniform, money, punishment, post office, progress of science. At least they're supposed to, according to the Constitution, but whatever. Define, declare, raise, to provide, make rules, provide here. And we go forward. Let me just double check here a second. All right. Okay, so we have establish, promote. Okay, here we go. It's at the very top. Sorry, everybody. I was like, where'd that go? All right, so under, let's make sure. This is Section 8 of Article 1. Congress has the power, so this is their duties, all right? The power to constitute tribunals inferior to the Supreme Court. Now, constitute means set up or structure. All right, so that's what we're talking about there. So that's the authority that Congress has. And then over here, we have Article 3 here. It's saying the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So they establish the courts so they can change the number of circuits. All right, we've got our circuits. Some people have been talking about adding a couple of circuits because we don't have enough circuits. And they can kind of divide up the courts and the different specialty courts. That's what they're talking about, all right? Ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation. Compensation is the money, and that means the Congress sets out the money, which shall not be diminished during their continuance in office, all right? So those are the big pieces of our judiciary branch that are in play, all right? It's not very much. The reason I bring this up is because Congress gets to decide how they want to design the courts, how many Supreme Court justices we have. That was decided in like 1898, I think, finally settled on 9. Compensation, gets doled out in the budget. And, again, we have our circuits. And I just did a full map of all of the circuits, including the DC circuit, that kind of explains where all of our circuits are divided. Let me see if I have my map here. Do I have my map? No, that's the mug shots. Nope. Well, it's not at my fingertips here. But the reason I'm telling you all this, because you're like, I want to know what to say to my senator about this bill, is they don't have the constitutional authority to restructure the kind of jurisdiction that they're talking about here. So when you go in and you look and you see, well, there are words in here that give Congress power. And in fact, one of the biggest questions has always been Congress trying to move their power away from the judiciary. And we had a Judiciary Act that started our entire Supreme Court process. Hold on here, everybody, one moment. Let me just grab that. Okay, is this it? No, that's not it. Where is it? Is it this one? Oh, here it is. Here it is. Okay. All right. So, the whole reason why we have a Supreme Court that's able to do judicial review is because these are the Federalist Papers, everybody. I'm sure you all have your own copy. Because of this case, Marbury versus Madison, right? I'm sure everyone's heard of that one. And I'm not going to spend, I won't go through it tonight, but Marbury versus Madison was all about judicial orders. In fact, this case that established judicial review is a fight between the president and the judicial branch. That's exactly what happened here. We had Congress creating a judicial statute, and within that statute, they had put in this writ of mandamus where the laws were set out in such a way that Jefferson was going to be forced to give commissions to judges that hadn't received them. All right, that was the question. So what John Marshall did was he went in and he looked at the Judiciary Act and he said, this part of the Judiciary Act is unconstitutional. All right, so they're talking again, it's very similar, about putting a Judiciary Act into play that includes things outside of the scope of what Congress is allowed to do. So who decides that? Well, the Supreme Court does. So if it goes into the Senate, it's better, I think, to ask the Senate questions like, how is this constitutional? Or this is unconstitutional? Or can you tell me how this is okay when it's been ruled not okay before by the Supreme Court? So that's why for me it's hard to give you exactly what to say when you're writing to your senators, because the law itself that they're creating is just unconstitutional. And you might say, well, they don't care. And that's true. They probably don't. But, if you're going to write to your senator and say this is, bologna sandwiches, you might want to just put in there, hey, have you read Marbury versus Madison? Have you read the Constitution, Senator? Do you know how a jurisdiction works for cases and controversies, So that's the direction I would go in here. What they're trying to do is change that jurisdiction regarding restraining orders and preliminary injunctions. And the other question could be like, well, why was it okay when Biden was president, but not okay now with Mr. Trump as the president? Like, what's the difference? So I think asking the questions can be as helpful as actually, writing the letter. So I suppose that's not a very good answer. That's a very lawyerly answer, but that's the issue that we're dealing with right now. All right, we're dealing with them trying to come in and change precedent set by the courts and the Supreme Court regarding the jurisdiction of the courts. So there is a question, and the other thing too, even with this Garcia case, everybody, there is a question that's been brought up to the Supreme Court multiple times. Can they rule on a preliminary injunction? Can they rule on a temporary protective order? That's what this whole bill's all about, all right? And what has happened in the last two cases that have gone up to the Supreme Court just within the last 10 days, what they've done is they've taken a restraining order, they've somehow molded it into a preliminary injunction where there is precedent for the Supreme Court to review it. So the Supreme Court fights about it. So it's kind of an ongoing fight. And so for Congress to kind of come in and be like, well, it doesn't really matter what you want to do, Supreme Court, we're going to make it this way when they do not have the authority to do that is kind of a big deal. So there you go. There you go. That's my really long answer to your short question. We're back. We're full circle, everybody. Back to Marbury versus Madison, where we've got kind of a president that just wants to do whatever he wants to do, and everybody else just has to do whatever he tells them. Wouldn't they be able to look at any issue that's based in law? Yes. But if you're talking about the Supreme Court, the issue with the restraining orders is that we don't have, it's the nature of both the preliminary injunction and the restraining order, because they're supposed to last for a very, very short period of time. So like 2 weeks max, all right? So it's the timing of it. And the cases have said, because it's such a short, quick, like triage situation, there's not enough time to put it up in front of the Supreme Court, have it briefed, have oral arguments, have amicus in there, in order for them to get the full idea of what's going on in the case. So it's not a final act being appealed. And as far as interlocutory goes, because it goes so quick, it seems like, well, they really can't deal with it because of how fast it goes and because it can be, changed in 2 weeks. So the exigency of the nature of the temporary restraining order is that issue. Preliminary injunctions can kind of go either way. There is some precedent allowing for those decisions. But yeah, of course, the courts have jurisdiction over that. And for, the Congress to come in and say, well, we're going to decide that temporary restraining orders or that judges only have jurisdiction over their particular circuit, when that is not at all what the precedent says, could be seen as, unconstitutional. Here's what I have to say, with the final way of putting this. The Supreme Court has set out that judges can do a temporary restraining order, an injunction for the entire United States. They've ruled on that. And that means the only way to overturn that ruling is to add an amendment or for the Supreme Court to come in and change their ruling. So Congress, with the little statute being like, la, 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 we want to change, blah, 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 when they're actually going against law done by the Supreme Court, it just isn't powerful enough because the Constitution will always win out. So again, long answer. A quick question. All right, here we go. Now, I wasn't even looking at the comments. How's everybody doing tonight? How are we doing? It's another day, right? Another day, another dollar spent. Just released pics, right? The whole restraining order issue with the domestic, right? The DV situation is completely irrelevant. Like it doesn't matter. And I know that's hard to kind of wrap people's heads around, but quite frankly, it doesn't matter if he had homicided people or had homicided his wife or had homicided everybody in the street or had, set something off in Oklahoma. It doesn't matter. None of those things are pertinent to the case at hand. So getting the public to understand that when it seems so callous and heartless is just incredibly difficult. It's one of the hardest things that we have to deal with in jury trials. So of course you want accountability for that, of course, but that's a different road. So when we're talking about due process and him being moved to El Salvador, that's road number 1. You talking about a DV situation, that's road number 2, and they do not cross. Only and also, though, to keep in mind, we don't have any criminal record. So that's another piece of it. We don't have a criminal record, meaning, that's not going to cross over. So those roads go parallel. They don't cross. All right. So it's difficult, but that's what they're trying to use. They're trying to justify removing someone from the United States because, they're an awful person. And they're going to continue to try to justify that. And the justification comes later. First is a proper procedure, and then justification is used as a defense. But we haven't even had the situation looked at this point with enough due process. If there was a DV situation and it wasn't addressed, bring it up. Bring it up during the hearings. Bring it up, when he's back. But you can't even have proper hearings when he's not even back in the country. So bring him back, set it all out in front of the judge when you get back. If it really happened, it happened. Let's talk about it. What do we do with that? Let's deal with it. But he has to be back in order for that due process to start working. Right. And I'm not saying that I support, bad behavior. Of course not. I'm an attorney. I put people in prison. That's how it's supposed to be. But also you have to follow the procedures, because the procedures, that's where you separate you can't really say this, the men from the boys, but I would say the women from the men. No, that's not right either. I don't want to say it in a way that's, I walked myself into a hole there, but that's the difference between just running around saying, don't do this, do that, versus actual, civility. So that's what's so important, is that, we have procedures because we're civilized, right? I mean, we didn't need them. We didn't need procedures when we were living in caves. You know what I'm saying? So that didn't turn out quite right, but that's what I'm saying. So it's like only those that are, not not able to. Adults from the kids. Well, maybe, but half the adults. I don't know. Oh my gosh, that's so funny. Yeah, I mean, if he's not a U.S. citizen, fine. That has been set out in the orders, fine. But even if you're not a U.S. citizen, you still have due process. I mean, we have case law, Supreme Court case law, that says if you're not a citizen, you still have due process. And so by not giving due process, you have violated the Constitution, your constitutional oath, right? You have directly violated a constitutional order that was given by the U.S. Supreme Court. So it'd be like in Miranda, right? So that the Miranda decision says, you have to tell them what their rights are. So instead, let's just say you throw somebody in the back of your car, your plain clothes, and you just start, beating the heck out of them and saying, like, you did it, didn't you? You did it. I know you did it. Tell me everything that happened. And so you force an interrogation out of somebody, and then the court's like, okay, yeah, that's fine. Did you give Miranda? No. Well, that's fine. It doesn't matter. It's okay. You can decide whether or not you want to use Miranda, police officer. It's the same thing, right? We have laws, we have rules, and in the rules, in the case law, it says due process. And so you don't get to come in and be like, well, he was a really bad person. He didn't deserve to get Miranda read to him. Like, what? That's not for you to decide. That's not up to you. We have a process here. Well, that's the thing. Is there trusted informant enough to prove it? That's the whole thing, is that perhaps it's possible. We don't know, though. We have rules of evidence that allow evidence to come in. And the reason we have rules is we want to make sure that evidence is credible. And so, bring the informant in, let them testify. If they're credible, they're credible. There you have it, and then we'll go from that direction. But we can't even ask those questions because we can't bring that informant in and talk to them. We can't sit there and say, all right, tell me what happened, because that can't happen if he's not in the United States, right? No, I've not gone through the pages yet. I'm early. I had promised to come on at 8 tonight, so I just came on a little bit early to do a Q&A and just kind of chat with everybody and see how it's going. Can you talk about the criminal contempt filing for? Yes. No, it's okay. I will be going through, that's actually the order I will be going through today once everybody comes on in. Once we hit 8 o'clock, I will be looking through this order. But to summarize what's going on, he's just saying, look, you clearly have shown probable cause that you violated my order intentionally in bad faith. So there has been a finding. So what he's done now is he said, look, you violated my order. Now you can fix it. Or if you don't fix it, now we're going to go forward with sanctions. So we already have basically, it would be the equivalent of being like, you've been found guilty of stealing, but if you put everything back exactly like it was and there's no damage, then we can go forward. But if you don't put it back, then, it's time for the sentence. That's kind of how it's going. It's possible international law could get involved, especially now with the cat in play. And that's going to be in play. If you're talking about El Salvador, you're going to have a cat in play. And once that's in play, that's a treaty that involves multiple countries in the United States and the United Nations. So now we're dealing with the global international law question with that. Yes. Sorry. Sorry. Whoa, what was that? Sorry about that, everybody. Here we go. Cat convention. Okay. Against. And then the TOR. And then, the URE. I'm trying to work around what we've got here. All right. So that's what this is. There's actually a treaty saying that you can't send people to places where this is going to happen. And because they did know and still did it, we've got a violation of international law. But we have codified that into our federal statutes as well with immigration. So we have U.S. law, we have international law. Chopsticks, I need a little... there's a lot going on right now, and I just can't help but use the chopsticks pen. Just makes me feel better about life. Oh, absolutely. That's fantastic. Yes, they can get involved. They can. But it's super early in this whole process. Like, if you think that the U.S. legal system's slow, go internationally, right? So they're waiting. They still have to wait and see what's going to happen within the next couple of weeks, because we've got all kinds of crazy stuff going. We've got 2 weeks of discovery that's supercharged, super fast. And so everyone's kind of keeping an eye on it. So they're going to need to wait and see what actually happens. Knowing they would, yeah, exactly. If he knew, which I think we all knew, then yeah, he can be held accountable under the CAT Act. Place attorneys in contempt of court. Yes, he can. He absolutely can. Now, I will be reading through this order here in just a few minutes. I'm a bit early tonight, but what you'll see is the judge says, fix it, or I'm going to figure out exactly which ones of you did this, and then we're going to have some, prosecutions happening. You will be prosecuted. So he has said that, I will figure out the people involved. And that could be the lawyers. It could be the various people giving the orders. It could be the pilots. It could be the, ground crew, whatever it is. Whomever it is, they could all be held liable, responsible, accountable for what happened. And he's basically saying, I'm not going to draw that list up right now because I'm giving you a chance to make it right. Can't we indict the Heritage Foundation? No, we can't. No, no, unfortunately, or whatever. I mean, whatever. No, we can't. We gotta get more specific. We're too broad with just the Heritage Foundation. It's too broad. You have to have a specific tort involved in that. Might not be a brilliant lawyer. I think you might be right. And one of the things that I think is so interesting, and for those of you who were with me last night over on the tube when we were going through the discovery order, was that they get 2 additional depositions if they need it, right? The plaintiffs do. And so who knows? They may want to do a deposition of Bondi. They may want to. Or some of the more higher up people, Mr. Marco. I mean, they may want to do that. So there's a chance that she could be deposed, so sworn in under oath and asked questions. Blackwater, I struggle to go down any of those roads because I just am so focused on court documents and the facts and evidence that I've got that are proven authentic. So I'm not going to shut the door and say it's not possible, but what I will do is just say that's kind of on my back burner right now. Right, Marco Polo. Well, if she lies under oath, right, then that's perjury, and that's 5 years. Can Marco be held accountable? Yeah, absolutely, he can. Absolutely. He may be one of the people named, right? So the JGG case with the contempt and the Garcia case, they go hand in hand. So that's why I keep like saying them interchangeably. Because they just go hand in hand. Any news from Rudy? No. Last I heard, they had reached an agreement, and he goes forward on his life. Yeah, a lot of people have said he's disappointing, and I'm a little surprised. I mean, but then again, you put someone in a powerful position, and bad things can happen. That was one of the biggest issues. And again, I've been doing a lot of research today on the history of everything. And one of the biggest issues, especially Madison had brought it up, was if we're going to give this kind of power to people by electing them, we have to figure out a way to keep them from, going power crazy, which is what, King George, hello. So that was the whole reason why we did checks and balances, why we had it so that the courts would come in and make sure everything was okay, and Congress would set the law itself because they were elected, and the president's like the weakest link in the three, but and that's how it's supposed to be, and they did that on purpose because they didn't want to have a situation come up where someone just got out of control and stayed forever. In fact, Madison was very worried about that the president would just stay over and over and over again. That's why Washington walked away. Independent body, that's a tough one. Because they do follow the suggestions, the recommendations, the orders of the president. And so that's kind of, it is the enforcement branch. So if the president comes in and says, I don't want you to prosecute these kinds of cases, they have to follow those rules. And for the DOJ to be completely independent that would be kind of tough. I don't think we'd be able to get much done. In my opinion, what is good is that the DOJ flips, though. Who heads it flips, and some of the top tier people can flip. But what we've had in the past is a pretty good structure of, middle of the road people that are like, we don't care about politics, we're here to serve justice, until now. And so now we've got a bit of a problem. Can the attorney petition habeas corpus in El Salvador so he can be released at least? So, interesting question. They don't have habeas corpus there. Their whole system is a lot different than ours. Their whole process, there's no rights over there. All right. I mean, I'm not going to try to sugarcoat it and be like, they do the best they can with what they've got. No, that is a bad place. Okay. When it comes to laws, when it comes to legal questions, you don't want to be there and have a legal violation because your bad things are going to happen to you. So there's no getting around that. There's some talk about some Democrats, I don't know, that are going to go fly over and try to talk to him and stuff. All I keep thinking to myself is I hope that label of congressperson protects them so they don't just get taken out at the airport. But I just don't know at this point. I just don't know. I wouldn't want to go. I can appreciate all the different places in the world, but there are some places where it's no good. It's no good. You don't want to travel there. You don't want to travel. Okay, there's a senator there now. Okay, well, hopefully he's got all of his documentation. It better be a guy. Oh, my goodness. Yeah, they were turned away. Well, right. So, we don't have any rules over there. There's no rules. We've got no rights. It's like home field advantage. So once you go over there, you have to play by their rules. which is one of the things for me when I travel. I tell you what, the scariest experience I've ever had was when I traveled to Central South America, because the rules there are bonkers. There's some bonkers rules, and Eastern, like Russia area, bonkers. All right. So that's some madness going on there. I don't know what they think they're going to do over there, but I mean, I can appreciate their passion for the situation and their understanding that this is really important to the American people. I absolutely understand that, but they wouldn't allow it. Well, right, short notice. Well, I mean, come on. I mean, they can do whatever they want over there. Literally, they can do whatever they want. Whatever. And he said, okay, wait. Let me back up. Here we go. He said the reason keeping him is because Trump's paying. Well, yeah, I don't doubt it. Who authorized the payments? Great question. Where's the money coming from? It's supposed to be coming from Congress, right? One of the things that a lot of people have said is that Congress needs to, step up and be like, we're not going to give you any more money, since he keeps freezing all of these federal funds that are supposed to go to places. So that's possible. They could do that. The request had to come from the U.S. Embassy. Well, there you go. But who's in charge over there? I mean, it's probably like not somebody who is. The fact that they're even making these deals with El Salvador, I mean, the embassy's probably like, hey, we know where we're at. Sign the deal in February. Yeah, I'm not surprised. Oh, yeah, we're paying. Of course we are. We're paying for all of these lawsuits, of which there are about 190 at this point. Every single one of those is being fought by the Department of Justice, which, is a government entity. So we're paying for all of that. Right, exactly. I mean, that's the thing. There are no rights there. There are none. You go into a black hole, and again, when I've traveled to Europe many times, and I've made sure I knew what the laws were when they changed, when I crossed borders. But if you go south, everyone, I mean, oh my gosh, it's one of the most beautiful places I've ever been in my whole life. It was gorgeous. But if you say the wrong thing, it's like you're done. That's it. You're out. Like, just be like, it's been nice knowing you all, because they have this all powerful power, and the rights that we have here are completely gone. Like, we're struggling right now because a lot of things are getting rolled back, and, we need to yell about that, because that's what we do here, because, we hold the line. But if you really ever spend any time in countries where there is truly no freedom at all, I mean, it'll scare the pants off you. Can the EU help? I think they're waiting right now. I think they're, already... The EU's like, what's up with all this tariffs crap, like, which way are we going here? Canada, I mean, all of our allies at this point are, like, hey, you just turned on us. So what are they supposed to do? But absolutely, the international community could get involved if they feel that there is a human rights violation going on. But I don't know if other countries just drop people off at that place in El Salvador. I mean, who knows? Maybe like Bangladesh is like, hey, we're coming over with another batch. I mean, I don't know how this whole system works. So I'm not sure. And so that's another thing, is like, well, are there contracts with other countries? Do they do this? Or is this just something special that, Marco drafted up with some people over a discussion? We just don't know. I'm not sure if it's a month, but I tell you what, $6 million is not enough to house that many people for the rest of their lives. That's why I keep asking this question. Well, how long is their sentence, right? How long are they supposed to be there? With Garcia, he's not committed any crimes. He doesn't have a sentence. He had to be, they were trying to get him out of the country, even though that wasn't right. But even if he was getting out of the country, how long is he supposed to be in a prison? Like, there's usually a reason why you're in prison, because you've committed a crime, but there's no crime here. That's another thing that makes this so freaking ridiculous, is because we don't have a crime, we don't have a sentence, we don't know how long it's supposed to be. Rumor has it it's a year, but there's no confirmation from the government. Michigan congressman. Okay, okay. Good to know. For a year. Yeah, exactly. But who really knows? Yeah, I mean it's not good. Yeah, deportation is not incarceration. Exactly, exactly. So, if you're removed from the country, you don't just go to a prison. They're like, hey, go back to, Madagascar, but you can only be in the prison. Like, that's not how that works. That's not right. That's not right. So none of this makes any sense at all. I doubt Congress approved funding for this. We would have heard of that. I have no doubt about that. That's why he chose the location. Well, yeah. I mean, I don't know. I keep thinking about the lemurs, and I'm like, oh, I hope the lemurs are okay. And that just makes you think of Madagascar. I don't know why I've been thinking about Madagascar lately. I've heard it's lovely there. I don't know their legal system, so I won't be visiting. Oh my gosh. Yes, entering the country is a misdemeanor, and he doesn't even have a misdemeanor because everything, he went through the proper process. He got his order to be able to stay in the country and then followed up. He did his follow-up interviews that he had to do every year. He gave them the paperwork. He went in and saw the people, and he did that for like 5 years. Every single time he needed to. And so, there wasn't any kind of crime going on here. I mean, he's been working with immigration for 5 years. So there's no, big whoop-de-doo. 2023. Okay, well, maybe he's not, he did his due diligence. They did not. Well, I mean, yeah, oh my goodness. I am live. But there's no terror. Yeah, who knows, man? Who knows? I just don't. It's frustrating. It's awful and frustrating for sure, everybody. It's terrible. Yeah, a lot of them aren't criminals. Well, yeah, and even if they are criminals, like we still have protections in place, like basic human protections. They're not great. All right, I'm just put that out there. They're not great, but they at least are there. So there are some things in place here. So even none of those, just very basic, bare bones rights. Yeah, like due process, right? I mean, come on. If it's worked for the UK since 1215, why can't it work over here in 2025? Like, come on, people. Right. So am I thinking about leaving the US? Oh, I'm glad you asked me that. I did a lot of research back in, what was it, 2017, I think? I did a lot of research and I looked around. There are some interesting programs where it's like, as an attorney, you can go into another country and kind of work within their legal system. And I did some research, and I'm just going to put it out there, everybody. I'm going to be completely honest with you. Even with what's happening right now, there are more rights in the United States than anywhere else in the world. I'm not saying I'm okay with what's happening. I'm not saying that that's okay. But what I am saying is that the rest of the world has a lot less rights than what we have over here. And for me, I was just uncomfortable. I was uncomfortable with the rules that I would have to follow in another country. So that was it. For me. And that's what was one of the pieces that was really important to me, or the number one reason. But it may not be for other people. I mean, there's all kinds of, yeah, the Scandinavian countries. That's the thing too, though, is I am mixed race, and I can pass for a Caucasian if I work at it. But the race relations in a lot of places also play a pretty huge role. So that's something that I also take into consideration. Canada is, yeah, Canada's got some problems still. I think Canada was probably the closest. If that is, if I was to move, that would probably be where I would head to. I would go to the UK. Yeah. If I work at it. Yeah, I got to work at it. I got to put on a couple shades lighter of my foundation. You know what I'm talking about. Right? All of my mixed race peeps out there, you know what I'm talking about. We can sometimes pass for white if we need to, or Caucasian. So, and I can also help other members of my family that may be a bit more brown also pass if we need to. So, Um, yeah, I mean, there's a risk. There's a risk. Canada's cold. Okay, you know what I'm saying. You know what I'm saying. I know. I know. Spoke to the VP, couldn't see her. Right, right, right. So it's very interesting. Very interesting. Yes. Well, it's good to see you too, Rusty. I'm glad you're here. So with that, everybody, I had said I'd start tonight at 8. I came out a bit early to kind of do some Q&As, but we'll go ahead and get started here, diving into the decision that came out today. Although before we dive both feet in, they don't have ice over there either. They don't have AC and they don't have ice. Isn't that weird? That's so weird. Anyway, I digress. So I have it on very good authority, everyone, that the talk is going to be going down on Sunday. It's the rumor is it's going to be dark and we're not going to be able to get back into it again. So I really want to take this time to say, I don't know if this will be my last TikTok live. It may be one of the last ones. I may be able to come back on in another day or two and have that one be my final, but we are definitely coming down to the end of the road, everyone. So I want to remind everybody, please, 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 please come find me over on the Tube. I do live streams at 7 o'clock Central, Tuesdays, Thursdays, and Sundays on the Tube. And I do it in the evening right now, but once the talk goes down, I will be doing like midday ones. So I just want to remind everybody, don't renew that subscription over here. For all of you that have subscribed, I'm so grateful for your support. I'm so thankful. But don't renew it. Come on over to the Tube. You can be a subscriber for free over there, but you can also, support. I can't remember what's called over there. You can support your creators at different levels over there as well. So if you want to be part of the extra community to help, you can do that over there. Yes. Well, right. So the information that I have right now, and again, I think it's pretty reliable information, is that even though the extension was until June, that TikTok has just decided, we've had it, we're done, and have done what they needed to do in order to make it go dark. And apparently, instead of just pulling the app out of the store, which is all they really needed to do, they're just pulling it. They're just pulling the plug on it. And they're tired of dealing with it. And I think with a lot of the stuff that's been going on in this country also, that's the rumor. And I think it's, I would say I'm about 95% confident that it's true. Yes. Yeah. Oh, I know. There's not going to be a deal. There's no deal. Any deal that could have happened fizzled away with the tariff game. So that's the information that I have. Yes, I am also on Skylight, so Blue Sky, and it's the same handle, only it's a hyphen instead of an underscore. And I'm starting to try to post there every day. I also am on Substack. I don't post there every day, but I'm trying to figure it out. I am on the Insta for anyone who's like, I don't know where to go. I'm on the Insta and I go and I look around, but I don't spend too much time there either. But the Tube and the Blue Sky / Skylight, that's where it's at, everybody. That's where it's at. Yes, I know, right? Yeah, Substack's really cool. I really enjoyed Substack because you can go live there. I've not gone live yet, but I'm going to try to take my time and dive into YouTube because there are a few things I want to add to my current process on the Tube of You once the talk goes down. So I've got some extra things going on there. So just remember, I'm going to continue. I just do it over there and I don't have to censor my language. So you've got wonderful moderators over there, great fun chat over there. You can just put it on your TV if you want, whatever. I'm really enjoying working with YouTube. It's a much less stressful situation. All right. It's more of a healthy relationship than it was over here. So just take a minute, pop over there, and subscribing is for free, of course. And then that way you'll know. I post probably 4 to 5 shorts a day. And then the long form, I do 1 to 2. I can't do too many long forms. So, pretty much every other day I'm posting a longer one. But yeah, I mean, I'm still posting about 15, 20 times a week. They're just in shorts over there. So you can just go to the shorts and then read through all of those in playlists. So recommend. Oh, good. Thanks, Katie. Yeah, we had a lot of fun. We have a lot of fun over there, everybody. But I just wanted to say too, take a look, scroll through your follow list, scroll through, find your creators, and figure out where else they are, and go follow them because it's going down. It's the ship is sinking. There we go. I got it. So this Sunday is what I'm hearing is when it's going down. That's what I'm hearing. Yeah, the trauma from last time. And I think we all kind of, insulated ourselves. A lot of the creators, we've been talking about it for a long time, like, moving over and how to get our followers to move with us to various places. So we knew this was coming. Some people were like, well, maybe a deal will happen. But as soon as the tariff situation hit, it was like, that's it. They're done. They're done. Yep. The TikTok. Yep. Yeah, it's the TikTok. Right. Screen record your following list. Exactly. That's great. Martial law, no. I mean, I guess, I don't know. They might call in National Guard to help support different states, but the states really have to do that. So maybe in DC, there might be some in DC martial law going on, but should we cancel our subscriptions? Well, I would say don't renew at this point. Don't renew. And I was trying to make sure people understood that too these last couple of months. Just don't renew your subscription. I'm not sure I would cancel it right now. Wait a few more days just to make sure because it'll automatically cancel if the app goes down. But you don't want to invest any more in it is kind of what I'm trying to say. You know what I mean? So just make sure, and just make sure you're hopping over. You have a longer set one. Yeah, if you've got a longer one, I mean, see if you can pull that subscription back. I mean, I don't know exactly if you can, get credit for the months that aren't involved, but if you can put it back and just say starting May 1st, no more subscriptions, I would recommend that. I would highly recommend doing that. Still have a bank info. Well, I mean, yeah, but true. There's a lot of that. Is there anywhere we can find this information? Well, right now I don't really have a authenticated source that I can shoot you to at this point. But as soon as I do, I'm still doing a little authenticating myself. But once I've got it finalized, I'll do a post on it. I'll do a post so everyone can go. Go to Play Store, cancel subs. Yeah. Monthly, just in case. Exactly. Like, of course, we want to support our favorite creators. But on the other hand, too, we don't want to be like, I've got, an 18-month subscription and then, you're charged for that. So I think it's good to kind of get out ahead of it. That's just my opinion of the situation. I think we knew it was coming. We just didn't know exactly when. So some of my information that I have received has said that it's coming up on Sunday. And I'm feeling like that could be, from what I've heard and from what other creators are saying, that could be very possible. All right, everybody. All right, here we go. So again, just a friendly reminder, I am over on the Tube of You. So let's dive in. Now that I have let everybody know what I know about that, first of all, this is the wrong one. Sorry, that's the declaration. We've got the JGG case that we've been following, right? This is the case where we had 5 people, Venezuelans, and they were caught up in this whole El Salvador situation. So they brought a lawsuit. And when they brought the lawsuit, everything was really super rushed. So everything was rushed. The judge happened to be at the courthouse at like 7 in the morning. So he was able to kind of catch it before it got too far out of control. But 7 in the morning until 5 in the evening, where he put a restraining order in place, right? So 5 to 7. And at 7 o'clock, no matter what, the restraining order was in place, meaning no one should have been going to the El Salvador under the Alien Enemies Act after 7 o'clock on that same day. Now, he told them, and you've probably heard this is the one where he said to the attorneys, turn the planes around, right? Turn the planes around. And that's the issue that we're dealing with regarding this contempt. He had a couple of hearings actually, and said to the government, like, what were you doing? What, did you not understand my order? And the government's like, yeah, we understood it. We complied with your order. And the judge was like, no, that's not right. And so then he needed to do an assessment of whether there was probable cause that they violated a court order. And he came back with this decision that was filed today. This isn't it. Hold on. He came back with this decision that was filed just today with a finding of probable cause for contempt. Now, the finding of contempt means, boom, we have contempt. Now he's giving them a chance to cure the contempt or to make it right. And if they don't make it right, meaning bringing everyone back that wasn't supposed to be there, or however it is that they need to cure the problem, then he will go forward to have prosecutors brought in to prosecute the case. All right. So that's where we're at. And that's what I'm going to be reading through tonight. I won't be reading, it's 46 pages. I won't be reading every single page here. I want to kind of give you, though, the most important pieces of it. They get so many chances. Well, it's interesting because we try to be so careful, because we try so hard to make sure the rules are followed and to give people chances to follow the rules. And, we want people to follow the rules. The judge wants people to succeed. He wants them to, fix the problem. He wants that more than he would want some kind of, jail time for contempt. But then, last resort comes in, last chance comes in, and, sometimes that's all we can do is pull in those sanctions. Absolutely, absolutely. This case is closed. Well, she doesn't get to close the case. Maybe she doesn't understand that because she's the defendant. She doesn't get to close it. This isn't her case. These are the cases brought by JGG and 4 others and Mr. Garcia. These are their cases. All right. Smashing car windows in Boston. Yeah, I'm not surprised. ICE is kind of getting a bit big for their britches, but it also happened during his last administration too. So, all right, everyone, let me dive in. I'm going to start reading just the introductory paragraphs to give you an idea of where the judge is going. Then I'll take you through the facts, and then we'll kind of just do the intro argument pieces, and then get to kind of like the highlights of the case. So we're not reading the full thing. All right. Yeah, everything's going to the Supreme Court multiple times. Yeah, they just filed an appeal in the Garcia case. So that's going to the Court of Appeals, then up to the Supreme Court, no doubt. Can't Bonnie get in trouble with her license? One would hope. One would hope. No judge has power of the president. Well, no president has power over a judge either, right? I mean, it's equal. They're equal power. Want jail time? Well, jail time's always, we never know what's going to happen with that. So we will see. All right, let me dive on in and to my moderators tonight. The trolls have been coming on pretty strong the last few days. So make sure you protect your mental health and do whatever you need to do. You have my full support. As you all know, my moderators are amazing and they work so incredibly hard, and I'm so thankful for them. So here's our case, and then today's decision is finding of contempt is what we will call this. Contempt. There we go. Did we spell it right? We did. We spelled it. Yay! All right, so here we go. Let me dive on in. Again, I will take breaks and do some Q&As as we go through this, rather than just reading straight through, or else I would have turned the comments off, but I think we'll be all right. All right, here we go. Am I lined up okay in here? To my moderators and my friends here in the chat, are we lined up all right? I just want to make sure. Okay, thank you. Appreciate it. All right, memorandum opinion. On the evening of Saturday, March 15th of 2025, this court issued a written temporary restraining order barring the government from transferring certain individuals into foreign custody pursuant to the Alien Enemies Act. That's what this is all about. We're not talking just about deportation. We're talking about using this act in order to justify that deportation when this act is a wartime act and isn't really in play. So we need due process in order to figure out if the law they're being deported under is legal, right? At the time the order issued, those individuals were on planes being flown overseas, having been spirited out of the United States by the government before they could vindicate their due process rights by contesting their removability in a federal court as the law requires. And that would be the Fifth Amendment. Due process. Rather than comply with the court's order, the government continued the hurried removal operation. Early on Sunday morning, hours after the order issued, it transferred 2 plane loads of passengers protected by the TRO into a Salvadoran mega prison. As this opinion will detail, the court ultimately determines that the government's actions on that day demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in contempt of court, in criminal contempt. So we do have civil versus criminal, and they're saying this one's criminal. The court does not reach such conclusion lightly or hastily. Indeed, it has given defendants ample opportunity to rectify or explain their actions. None of their responses has been satisfactory. One might nonetheless ask how this inquiry into compliance is able to proceed at all, given the Supreme Court vacated the TRO after the events in question. That court's later determination that the TRO suffered from a legal defect, however, does not excuse the government's violation. Instead, it is a foundational legal precept that every judicial order must be obeyed, no matter how erroneous it may be, until a court reverses it. If a party chooses to disobey the order rather than wait for it to be reversed through the judicial process, such disobedience is punishable by contempt, notwithstanding any later revealed deficiencies in the order. That foundational rule of law answers not just how this compliance inquiry can proceed, but why it must. The rule reflects a belief that in the fair administration of justice, no man can be a judge in his own case, no matter how exalted his station or righteous his motives. The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it. Now, I'm going to just make a side note comment here. When we're talking about the 3 branches of government for Congress, right, they have their constituents, the people that that voted for them. They're kind of beholden to them. And the president, also elected, beholden to the people of the United States. But the Supreme Court, the judiciary, is not beholden to anybody except for the Constitution. And that's what makes it so powerful and why those orders have to be followed, because ultimately they speak for the Constitution. To permit such officials to freely annul the judgments of the courts of the United States would not just destroy the rights acquired under those judgments, it would also make a solemn mockery of the Constitution itself. So fatal a result must be deprecated by all. All right. So that's kind of our intro here, and then I will dive into the factual background so that everyone's got the same set of facts to work with here. All right, here we go. Background A, factual backgrounds. As just noted, the injunction in question was issued on the evening of Saturday, March 15th, a day of events that moved at breakneck speed because of the government's apparent effort to remove individuals more quickly than the judicial proceedings in which it was actively participating could keep pace. The day prior, the president had seemingly signed, but not yet made public, a proclamation invoking the Alien Enemies Act. Through the 1798 Act, Congress granted the president broad authority if there is a declared war with a foreign nation or government, or if a foreign government has perpetrated, attempted, or threatened an invasion or predatory incursion against the territory of the United States. And this is the statute itself. In such a scenario, and if the president makes public proclamation of the event, he is authorized to apprehend, restrain, secure, and remove any natives, citizens, denizens, or subjects of the hostile nation or government who are 14 years or older. In his proclamation, President Trump announced that the government would use the act's authorities to apprehend and remove members of this group, a violent Venezuelan transnational group that had recently been designated a foreign T organization. To support that finding, the president asserted that the Venezuelan government of Nicolas Maduro indirectly relies on this group and has been infiltrated by the gang. He further announced that the gang had committed or attempted an invasion or predatory incursion upon the United States, including through DRUG trafficking, mass illegal migration, and irregular this kind of fare, though he provided no examples of the last. I do need to watch my language over here, everybody, because I will get pulled. My live will get pulled if I say a certain word too many times. So don't have that problem over on the tube. Just reminding y'all. Although the proclamation was not published until 3:53 p.m. on Saturday, defendants had begun setting act-based removals into motion weeks earlier. Beginning in early March, the government interrogated Venezuelans in its custody about alleged membership in this group and transferred many of those it deemed members to the El Val facility located outside Harlingen, Texas. Oh my gosh, everybody. Oh dear. Hold on here. All right, there we go. Listen, TikTok, some of us have vision problems, so your new puzzle's not very good. All right, where were we? That was not a very fun situation. All right, we made it. Here we go. Not far from the Mexico border, the reason for staging them together at El Val became clear on Saturday, early that morning when the signed proclamation was still hours from being disclosed to the public. The government reportedly loaded scores of Venezuelans onto buses, drove them into a nearby airport, and began putting them onto 3 planes. Those were 3 planes involved now. And he is citing the declarations that were filed by the ladies. Government counsel agreeing defendants were acting in preparation of the proclamation before it was posted, which the government attorney had admitted during one of the hearings. As the plane sat on the tarmac, officials refused to answer the deportees' questions about where they would be taken. Again, citing the declaration. Among those queued on the tarmac or placed onto planes that morning were the 5 plaintiffs in this lawsuit. Apparently catching wind of the impending proclamation, they filed suit at 1:12 a.m. on Saturday before the buses left El Val and then moved for a TRO, preventing their removal under the proclamation. So the only reason these 5 were able to do anything was because they'd heard a rumor and they filed the lawsuit at 1:12 in the morning. So if this had been old school days before you could file things online, it would have been over. In addition to asserting that the proclamation lacks a legal foundation, each plaintiff adamantly denies that he's even a member of this group. Again, citing those declarations here. Around 8 a.m., the court learned that it had drawn the case through the court's random assignment system. Hopefully I'm up high enough so everyone can see the chat okay. Just double checking here, everyone. Are we all right? Okay. Chambers then reached out to locate government counsel. Less than an hour later, plaintiff's counsel informed Chambers that at least one plaintiff was reportedly already aboard a removal flight, having not yet heard from the government, and given the exigent circumstances prompting the need to freeze in place the status quo until a hearing could be held. The court entered an ex parte TRO, preventing defendants from removing the 5 plaintiffs for 14 days. I know you can't see, I'm skipping here. Not long after the TRO issued at 9:40 a.m., government counsel informed Chambers by email that the TRO had been disseminated to the relevant executive branch agencies. Sure enough, several of the named plaintiffs report that they were abruptly removed from the planes. All right, everybody, pause for a moment. Listen to this, all right? Several of the named plaintiffs report they were abruptly removed from planes. So they knew that there was a restraining order, and they removed the people named in the lawsuit, pulled them off of the plane. That means there was time to not have the planes go. All right, are you following me with that? Whoo, this is not good. This is not a good situation. Evidence that defendants were able, if they wished, to ensure that people on the ground knew relatively quickly of developments in the court proceedings. Yikes. A government stating on Saturday evening that relevant agencies had confirmed named plaintiffs were not to be removed. At 10:15 a.m. in an email thread including Chambers and counsel for both sides, plaintiffs asked the court to hold an emergency hearing on their pending request to provisionally certify a class comprising them and those similarly situated and issue a second TRO covering the whole class. This means they're rushing to try to get everybody else. So these 5 plaintiffs were pulled, and they were rushing to get anyone else pulled that was on the planes under this act included in the complaint, right? So they would be protected. So they were rushing to certify a class of people that fell under this Alien Enemies Act situation. The government objected that a broader injunction in a hearing on the issue would be premature, and it asked the court to wait until Monday for a hearing. The government notably did not respond to plaintiffs' pointed question about whether it was prepared to halt removals pursuant to the act. Again, this is the Alien Enemies Act in the interim. So just after 11 a.m., the court set an emergency hearing for 5 p.m. that same afternoon. Shortly after, the proclamation appeared on the White House website at 3:53 p.m. And about 45 minutes before the hearing began, plaintiffs' counsel informed Chambers that he believed that 2 flights, both operated by a contractor used by Immigrations and Customs Enforcement for deportations. So now we know who the the planes were scheduled to depart Harlingen that afternoon. Counsel expressed concern that the flights might imminently take off with his 5 clients and members of the potential class on board. The government again offered no response. So after they had made that class determination, now anybody on those planes who had been pulled under the Alien Enemies Act had a protective order on them. In the 5 p.m. hearing, the court clarified the limited scope of the TRO then in place and turned to whether it should provisionally certify the class. The government began by objecting that venue was improper because plaintiffs' claims could be raised only through a petition for habeas corpus in the federal district in Texas, where they were being held, not in the District of Columbia. Noting that it would benefit from further argument on the issue, the court pivoted to addressing plaintiffs' concerns about imminent deportation. It asked the government point blank whether there were any removals under this proclamation planned in the next 24 to 48 hours. Government counsel said he did not know, but that he could investigate and report back. Plaintiff's counsel then interjected that various sources had informed him that the 2 removal flights that were scheduled to depart that afternoon may have already taken off, including during this hearing. So at 5:22 p.m., the court adjourned the hearing until 6 p.m. and directed government counsel to find out whether the government was in the process of removing people under the proclamation. Thank you, Kaya. Tea break. Here we go. I've been talking a lot over the last couple of days. So my voice is a little bit more scratchy than normal. All right, it was. Although the government has refused to provide the particular details, all evidence suggests that during the short window that the court was adjourned, 2 removal flights took off from Harlingen, one around 5:25 p.m. and the other at 5:45 p.m. And then here he's citing where he's getting that information from here as well. So, flight tracking information. More here. Okay, so those, and again, these are different. If you'll note this, look at this, that Buckley guy, Buckley, right here, 8:13 a.m. So even because we've got different posts and things, man, these people just, they make the evidence for us. We don't even have to go looking for it. They just make it themselves. So there you go. Those later discovered flight movements, however, were obscured from the court when the hearings resumed shortly after 6 p.m. because the government surprisingly represented that it still had no flight details to share. Here, and then he's citing the transcript. Defendant's counsel later affirming that at the time he had no information from the government as to the status of the flights. When pressed, government counsel stated that the operational details he had learned during the recess raised potential national security issues, so that they could not be shared while the public and press listened to the hearing through a call-in line. I was on that line. No, I don't know, actually. That was March 15th. I might have been. I don't know. He suggested, however, that the government could provide the court with additional details in an in-camera setting, meaning in chambers. So the court arranged to do just that. It disconnected the public line so that only counsel for the parties were present and asked government counsel to report. Except that he did not. He clarified only that the additional details he had just mentioned could eventually be provided in camera, in chambers, but he had no information to share at that time. So this lawyer says to the judge, I can tell you the information that you need in chambers. So everything stops. They go back into chambers. And then he says, oh, well, I mean, eventually in chambers. Why would he do that? Stalling for time. That's why he would do that. All right. With the growing realization then that the government might be rapidly dispatching removal flights in an apparent effort to evade judicial review, while also refusing to provide any helpful information, the court turned to the pending legal issues. After hearing arguments, it first determined that venue was proper, and it next provisionally certified a class of plaintiffs covering all non-citizens in custody subject to removal solely under the proclamation. The court then addressed the sole remaining question, whether it should issue a broader TRO covering the entire class. It concluded that this was appropriate because plaintiffs had satisfied the factors governing emergency relief, and because the distinct possibility, unrebutted by the government, that flights were actively departing or planning to depart required an immediate order preserving the status quo. The court therefore ordered that for 14 days the government was enjoined from conducting the removal of any non-citizens in its custody solely on the basis of the proclamation. Then at about 6:45 p.m., the court delivered an oral command. I love this. This is something that the government's like, you didn't really say it. So I love how the judge is putting it here. clarifying that what compliance with the TRO meant. It directed government counsel to inform your clients of the order immediately and to notify them if class members were on a plane that's going to take off or is in the air. Those people need to be returned to the United States. However that's accomplished, whether turning around a plane or not disembarking anyone on the plane, I leave it to you. But this is something that you need to make sure is complied with immediately. So again, we pause, everyone, and we say, these planes, even if they were up in the air, once they landed in El Salvador, he's saying, don't pull them off of the plane. Keep them on the plane. But did they? No, they did not. So there were several times where this could have stopped after they knew this order had been issued. The hearing adjourned at 6:53 p.m. Roughly 30 minutes later, the court memorialized the TRO in a written order. That order referenced the just concluded hearing and reiterated that the government was enjoined from removing class members. Despite the court's written order and the oral command spelling out what was required for compliance, the government did not stop the ongoing removal process. According to defendants, the two planes that took off during the adjournment departed U.S. airspace before the court's 6:45 p.m. oral command. And then we've got the declaration here, and, quote, landed abroad sometime after the court posted the minute order at 7:25 p.m. A third flight reportedly took off from Harlingen, I don't know how to say that, everybody, at 7:36 p.m. But the government maintains that all aboard were removed under authorities other than the proclamation. The first two planes, those carrying members of the plaintiff class covered by the TRO, apparently touched down in Honduras at 7:37 p.m. and at 8:10 p.m. and remained there for several hours before taking off again for El Salvador. Again, another opportunity after the planes landed in El Salvador shortly after midnight on Sunday. Most of the passengers were apparently transferred into one of that country's prisons, known as the Center for T Confinement. But not all passengers, it seems. One Venezuelan woman swears in a declaration that she was on one of the flights that landed in El Salvador, but was flown back to the United States along with 7 other women, apparently because Salvadoran authorities on the ground refused to accept any female prisoners. So they didn't even get in there. They, stepped off the plane and they're like, you're going back. We're not going to take you. Her account is corroborated by a declaration from a Nicaraguan man who avows that he was also on board one of the removal flights, but was returned alongside the women because Salvadoran officials would not take custody of Central American nationals, such as himself. Whew. By mid-Sunday morning, the picture of what had happened the previous night came into clearer focus. It appeared that the government had transferred members of the plaintiff class into El Salvador's custody hours after this court's injunction prohibited their deportation under the proclamation. Worse, both by defendants intimated that they had defied the court's order deliberately and gleefully. Whoa, you don't want a judge to ever say that. The Secretary of State, for instance, retweeted a post in which above a news headline noting the court's order to return the flights to the United States, the president of El Salvador wrote, quote, oopsie, too late, laughing face, end quote. Man, these people. All right, so there's our factual background. All right. Yeah, gleefully. Oh, it's awful. I know it's awful. So it's our factual background. So now we'll get into the procedural background. Again, this gives us the history of how this case has been proceeding. So tea break. All right, next up. A filing submitted by defendants on Sunday afternoon failed to dispel any concerns that they had flouted the court's injunction. So the court set a hearing for Monday, March 17th. So everybody, this was the first time that we were really hearing about what was going on. Everything was really mixed up over the weekend, But Monday was when we were starting to see the court filings come in. Well, by we, I mean me. I was starting to see court filings coming in, and it was like 5 a.m, and I'm like, what the H is this? This is crap. To determine what had transpired over the weekend. The court expected that at the hearing, defendants might explain that, despite appearances otherwise, none of the people on the first 2 flights was a member of the plaintiff's class. Or at worst, defendants would admit to a grave mistake, explain how it transpires, and detailed plans to rectify it. The United States government took neither tact. Rather, what followed in the ensuing days was increasing obstructionism on the part of the government as it refused to answer basic questions about what had happened, questions that were all ultimately in service of resolving one key fact: whether members of the plaintiff class, that is, non-citizens removable solely on the basis of the proclamation, were transferred out of the U.S. custody after this court's injunction preventing their deportation. Such stonewalling started before the Monday hearing. Just before it was set to begin, defendants sought to cancel it as an unnecessary incursion of executive branch authority. And then they had a motion to vacate the hearing filed. Nowhere in their filing did they dispute that class members were transferred into Salvadoran custody hours after the injunction issued. Instead, defendants set forth several hyper-technical legal arguments. Ooh, I love that. Legal arguments for why, in spite of that fact, they had complied with the court orders. Just making sure I'm in frame properly, everyone. There we go. Such arguments were unconvincing then and remain so now. Then in the hearing itself, the government refused to provide any relevant facts. The lawyer the government sent to the proceeding, conveniently not the counsel who had appeared at the TRO hearing, repeatedly stated in some form or another that he was not at liberty to disclose anything about any flights. Although he would not say that such information was even classified, he claimed that it could not be shared even ex parte, which means just with one party, without even having the plaintiffs present, with the court, because of diplomatic concerns and national security concerns with flight patterns and things of that sort. It's very possible someone could go to jail here. They have an opportunity to cure. If they don't cure, there could be some people going to jail. That is, the government maintained that it could not share any details about the flights, even privately with the court, despite the fact that the previous day, defendants had retweeted a 3-minute video that portrayed a host of operational details. So the 3-minute video is okay, but you can't tell the judge anything privately. Are you freaking kidding me? In high definition, the video displayed the planes and runway where they parked, how migrants were restrained and transported, the faces and uniforms of many detainees, guards, and other officials, where the vehicles apparently entered this place, and the inside of the prison. Man, Salman, you are really, really persistent, dude. You are just very persistent. So don't ask again. Thank you. So on Monday evening, the court ordered the government to submit another filing the next day, seeking to accommodate defendants' national security concerns, vague as they were, yet nonetheless needing answers on how members of the plaintiff class had been transferred into a foreign prison hours after the injunction issued. The court directed the government to explain its position on whether and in what form it will provide answers to the court's questions regarding the particulars of the flights. The court again offered that such information could be provided in camera, so in chambers, including in a classified setting. In their March 18th response, defendants reiterated their various arguments for why they should not have to share information related to flights, but conceded that if ordered to do so, they would submit an in-camera and ex parte declaration. The court ordered defendants to do just that by noon the next day, and it set out 5 basic questions that the declaration needed to answer: when the 2 flights in question took off and from where, when they left the U.S. airspace, when they landed in a foreign country or countries, what time people subject solely to the proclamation and not other authorities, such as Immigration and Nationality Act, were transferred out of U.S. custody, and how many people were on the flight solely on the basis of the proclamation. Defendants then, hold on here, everybody. Defendants then reversed course entirely. On Wednesday morning, the 19th, a few hours before their deadline, they moved this court to stay its Tuesday order on various grounds. Sorry, tea break, everybody. One moment. Most relevant, they asserted for the first time that they were considering invoking the state secrets privilege over the flight details and needed more time to make that determination. The court was unsure how answering its 5 questions could jeopardize state secrets. Defendants, after all, had publicly shared images of the flights, making them trackable, and had still not claimed that the questions bore on any classified information. So this is another thing here where the judge is saying, you couldn't tell me anything, but you have these videos all over social media. So, clear that up for me. Make that make sense. But nonetheless, sought to accommodate their last minute request. It gave them yet another day either to answer the 5 questions or to invoke the state secrets doctrine. Oh, goodness gracious. On Thursday, the 20th, the government again evaded its obligations. Rather than invoke the privilege or answer the questions, it submitted a short declaration from an Immigration and Customs Enforcement officer stationed in Harlingen. It was his, quote, understanding, end quote, he said, that the cabinet secretaries were then considering whether to invoke the privilege. In response to this wholly inadequate response from a low-level official, oh, ouch, that's not very nice, without any actual knowledge, whoa, this judge is mad. The court required defendants to submit a declaration from someone directly involved with the cabinet-level discussions and gave defendants 5 days to indicate whether they were invoking the state secrets privilege. Oh, my goodness. This judge is like, I'm just about had it. I love it. I love it. All right. Here we go. The government has since invoked it. The court also directed the parties to brief whether defendant had violated the court's TROs. That briefing is complete, and the court held a hearing on the matter in early April. In parallel to the investigation of defendants' compliance have been further proceedings on the TRO's merits. After briefing and a hearing, the court denied defendants' motion to vacate the TROs. It held that the plaintiffs had shown a likelihood of success on one of their core claims. Those subject to removal under the proclamation had a due process right to challenge the government's determination that they were removable and that they would face irreparable harm if the TROs were dissolved, a harm that also tipped the balance of equities in their favor. So this was the test that he used. The Court of Appeals then rejected defendants' request to stay the orders, raising concerns with both the applicability of the act and the lack of due process here. So the Fourth Circuit, is that the fourth or was it the first? Sorry, everybody. It's the DC Circuit, my bad. I'm getting it mixed up with the Garcia case. The Supreme Court subsequently vacated the TROs on a narrow ground. It held that challenges to removal under the Act must be brought through a habeas corpus proceeding, not as plaintiffs did through the Administrative Procedure Act, and therefore venue lay in the district in the class member's confinement, not the District of Columbia. So, quick side note, everyone, the habeas corpus literally means bring forth the body. This is a request that you make of a court to see you. You say, look, the government's holding me illegally, and I want you to see me so that I can tell you why it's illegal. That's a habeas corpus action. And you do that in the form of a writ. All right, so just to be clear on what that exactly means. So, next up, while the court split on the venue question, I remember what I was going to say. I forgot. So the venue issue is On habeas corpus action, you're saying to the court, the government's holding me. Now, the question is, well, where are they holding you? That's why they're using confinement here as their venue. So it was filed in D.C. because, it was D.C. We've got immigration issues going on. We've got all kinds of other things going on. So D.C. seemed like the proper venue. And for this case, it was fine. But what the court is saying is for habeas corpus cases, which this is not, but for habeas cases, you need to be in the place where you're being confined. All right, so there you go. It unanimously held, as this court did when declining to dissolve the TROs, that those subject to removal under the Act must be allowed to challenge their removability in federal court before being deported. Here we go. Specifically, all justices agree that due process clause requires the government to provide anyone it seeks to remove notice that they are subject to removal under the Act, and to do so within a reasonable time and in such a manner as will allow them to actually seek habeas relief before being removed. And that was another one of the big issues that the judge was bringing up during multiple hearings, was you guys are moving so fast that they don't have time to even assert their rights. Like, they filed at 1 a.m, and then all of these other things happened and they barely got off the planes. So not only do you have to provide a habeas corpus as a process for them to go through, you need to give them enough time to be able to file it. And that was really important to the judge and as a practical matter. In holding as much, the court effectively said that the Constitution flatly prohibits the government from doing exactly what it did that Saturday, when it secretly loaded people onto planes, kept many of them in the dark about their destination, and raced to spirit them away before they could invoke their due process rights. As this opinion will shortly explain in greater length, the fact that the Supreme Court determined that this court's TRO suffered from a venue defect does not affect, let alone moot, the compliance inquiry presently teed up here. So that is the procedural history for this particular case. So I think the judge did a pretty good job kind of summarizing it. So we'll do a little Q&A and then I'll keep moving forward here. So does that make sense, what we're talking about here with the habeas action? Because under the Alien Enemies Act, technically, there's no say that you have to have a habeas action. So that's one of the reasons why they were using the Alien Enemies Act, is because they could just grab a whole bunch of people, put them on planes, and put them wherever they want. Because they're saying, you're an AEA. So what they're saying here, what the Supreme Court ruled on, which is such a huge, huge thing, was they said, even if under the Alien Enemies Act, you're trying to move people, they have to have due process. That set precedent. And I know there's been some talk of the Trump team won the case. I'm like, what are you talking about? What happened with the Supreme Court was they said everybody gets due process, even non-citizens. Every single person gets due process, and that's set in stone now. So that was very important. What was wrong with venue? It's because of the nature of the habeas case, right? So habeas isn't like, I've been wronged. I didn't do it. Habeas is saying they are holding me. They have kidnapped me. They are restraining me against my will, against the law. And so that's the crime that's occurring. That's the action against the government that's occurring for a habeas case. So what they're saying is, well, where are they holding you? Because that's where the wrongful act is occurring. So they were in Texas. These plaintiffs were in Texas. So that's why the Supreme Court said, basically, where you file habeas, where your confinement is, as opposed to, where you reside or where the incident happens, right? So that was the venue issue. Yes, that was the venue issue. Mm-hmm. Yeah, the 27 grievances in the Declaration of Independence just are a smack of what's happening these days, for sure. Civil versus criminal, it depends, I think, on the intent and what's going on in the case. Why is it legal to imprison someone versus simply deporting them? Well, right. Right. So, I'm not really sure how to dive into that particular one. Why is it legal to imprison but not deport? Because, to imprison somebody, you do that because there's been a crime that's been committed, and a statute sets out how long they're supposed to be in prison for, right? So that's your punishment. Deportation is just very simply like, well, you don't have papers to be here, so you got to go. I mean, there's just two very different animals, right? So one involves some kind of criminal act you've been found guilty of. Another is like, well, your paperwork doesn't check out. We've denied you asylum or whatever. So this isn't going to work out for you. So you need to go. That's the situation. I agree, Casey. I agree. Deprivation of liberty. Yes, yes. Law student have been, oh yeah, well, welcome. And I'll take this moment, everybody, to remind you that I do lives 3 times a week over on my Tube of You channel. This app's going to be going down. So, after today, there may be one more live here, but I'm not sure exactly when the plug's being pulled, but I'm over on the Tube of You. So if you are wanting to follow this case with me, go on over and subscribe over there. Has the government told me anything? Not yet. No, I don't think so. All right, so let's take a look at the next piece here. Just again I think it is going to be going down on a Sunday, and I've been doing my lives over there. This one's a special case. That's why I'm back over here. But I just have to remind everybody, just, go over, subscribe to your favorite creators so that you don't lose you don't lose your fun creators that you enjoy. All right, here we go. Analysis. This gets the judge is pretty straight up frustrated in this particular situation. So I'm going to kind of cruise through this. Analysis. Defendants provide no convincing reason to avoid the conclusion that appears obvious from the above factual recitation that they deliberately flouted this court's written order, and separately its oral command that explicitly delineated what compliance entailed. They do not dispute that it was hours after the written order issued when they disembarked the class members aboard the 2 planes and transferred them out of U.S. custody, rather than offer a new mea culpa and attempt to explain this grave error. So, right, to say, like, my bad is basically what they're saying here. Rather than just be like, oh, we made a mistake, and try to explain it in detailed plans to rectify it, defendants offer various imaginative arguments for why they nevertheless technically complied with the order. None of those positions withstands scrutiny. Defendants' core contention that in prohibiting class members' removal, the written order barred only their physical exit from the United States, not their subsequent transfer to Salvadoran custody, requires ignoring the clear context in which the order was issued. Their other arguments amount only to retroactive attacks on the legal validity of the injunction. But that road leads nowhere. Even a legally defective order must be complied with until reversed through the appeals process. Defendants' conduct, moreover, manifests a willful disregard of the court's legally binding proscriptions. So this term, willful disregard, this happens a lot. This is a lot of the language that can be used for ethical violations, and it also is a mens rea or an intent level that can be used in crimes. So it's, the same as saying, well, this was premeditated homicide. One of the pieces of manslaughter could be willful disregard for the safety of another person. So this is a legal term of art that we used for that. Given the evidence at this early stage in the inquiry and offered no persuasive reason to conclude otherwise, the court finds that there is probable cause that the defendants acted contemptuously. So we've got our holding here again, that the judge is just saying, look, we've got it. We've got probable cause. All right. So I do like to take a moment when we reach to our burden of proof level to just explain quickly what I'm talking about when we say probable cause. All right. So I guess we'll just use the chopsticks. All right. So a burden of proof, right, is what is required in order to win or lose, right? So you have to meet your burden of proof. Now, burden of proof is on a spectrum. We don't have an absolute definitive answer for burden of proof. What's on our spectrum here is that we've got reasonable suspicion. That's our first level. So reasonable suspicion to believe criminal activity is afoot. That's here. Then we have over here guilty beyond a reasonable doubt. So beyond a reasonable doubt is our most stringent level. Okay. So next, over here, we have probable cause. Probable cause is what we use in order to get warrants, to do arrests, to indict. So our indictment by a grand jury, those kinds of things have to be at a probable cause level. And in order to win a civil case, we have to have on a preponderance of evidence. And that means a 51% sure of somebody's fault level, all right? So when you're taking a look at what exactly it means, you have to look at it like we're building a road. Reasonable suspicion to believe criminal activity is afoot, that can get you a Terry Pat, that can get you some kind of a plain view situation, but reasonable suspicion here based off of whoever is enforcing its education and understanding. Reasonable suspicion, so stop and frisk situation. Probable cause, that means based off of the totality of the situation that it's very likely this person did commit the offense that you think they committed. And we use this in order to get our warrants, to do our indictments, to get into a car without a warrant. So we've got the Carroll Doctrine. That's the next level. And then we have preponderance of the evidence, which means 51% someone's at fault in a civil case. And then a guilty requires beyond a reasonable doubt in criminal court. Each one of these. So what we're saying here is we've got probable cause to believe that they violated the court order. All right. This is the level we're at. We don't have to have beyond a reasonable doubt. We're not dealing with a criminal case at that level. We're in a quasi-criminal situation because it's contempt. And that means that our level's only probable cause. All right. So you're going to hear the judge say that multiple times because that's the standard of proof. And it's important for that distinction to be made here so that we know we're not dealing with beyond a reasonable doubt. We're also not dealing with just reasonable suspicion. Like, oh, I think that person did it. We're at a higher level than that. And then we have other things like clear and convincing evidence, but, that's another night. Let's dive back in here. Sorry, the chopsticks jumped away. Here we go. Right. Willful and knowing actions here constitute probable cause for finding contempt. So that I thought was really important to remember that probable cause level. Here we go. Let's go through contempt and we'll just do kind of an introductory piece and then we will skip forward. What are the procedures of evidence? So when we're in kind of a quasi-criminal situation, when we're dealing with a contempt, we do have rules of evidence that we use, but they're not as stringent as they are at trial. So depending on your jurisdiction, but you can have things like hearsay come in. Those may be allowable, prior criminal records. And these are things that are not allowable in criminal cases. So prior crimes can come in. There can be just the rules are more relaxed. We still have rules, but they're just much more relaxed in a quasi hearing. This is more of like an administrative criminal hearing. That way, the evidence rules are important and we make a record, but we also aren't as strict as we are if we're in front of a jury. Here we go. Legal standard. When Congress established lower federal courts in the Judiciary Act of 1789, which is why we have 9 justices, it conferred on them the power to punish by fine or imprisonment at the discretion of said courts. Ooh, you don't want a judge saying that. You don't want a judge saying that in your in your finding of contempt. You don't want that. Oh my goodness. All contempts of authority in any key, in any cause or hearing before the same. Yikes. In doing so, Congress gave federal courts the discretionary power to punish for contempt as that power was known to the common law. So, judge-made law. The power to fine and imprison for contempt from the earliest histories of jurisprudence has been regarded as a necessary incident and attribute of court, without which without which it could no more exist than without a judge. Although Congress eventually pared back federal courts' statutory contempt power, it preserved their authority to punish, among other transgressions, disobedience or resistance to court orders. Yikes. Oh, the language here. He's building his case. That statutory authority is now codified in 18 U.S. Code Section 401, which provides that any court of the United States shall have the power to punish by fine or imprisonment, or both, at its discretion, disobedience or resistance to its lawful writ, process, order, rule, decree, or command. For a contemner, come on, people, to be convicted of criminal contempt under Section 401(3), it must be shown beyond a reasonable doubt. All right, so see how this is important? So he's got probable cause to believe that there was some contempt going on. But if we want to go further than that and actually hit sanctions, we need to get in beyond a reasonable doubt. And that's because your freedom could be pulled from you. Anytime your freedom is in question, then that's why we've got that beyond a reasonable doubt element to it. So that's the burden of proof. It must be shown beyond a reasonable doubt that the court order was clearly and reasonably specific. 2, defendant violated the order. And 3, that the violation was willful. The court here inquires only into whether there's probable cause that defendants violated Section 401. Such an inquiry does not appear to be strictly necessary. The statute does not include a probable cause requirement, and as the Department of Justice has explained in an internal manual, it is unclear whether probable cause that a willful violation has occurred is a condition precedent to the commencement of a criminal contempt section. So he's saying, I don't even know if we have to find probable cause, but that's what we're going to do. We're going to do it anyway. That's how that's going to go. In practice, the vast majority of criminal contempt decisions make no mention of such a requirement. Some courts, however, have opted to make or require findings of probable cause before initiating criminal contempt proceedings. And he's got all of these cases he's citing here. So he's just trying to be extra super careful. And every single step along the way has to be perfect. The court finds that practice to be a prudent way of affording alleged contemners the procedural protections associated with other criminal proceedings, and so follows it here. Now we are getting an explanation then why he is looking for probable cause instead of just setting it up and knocking it down in court like most people would do for contempt. Depending on your jurisdiction. If it's a really controversial case, I think absolutely you're going to want to do as many steps as possible to create that record. Now I'm going to fast forward a little bit here. Effect of Supreme Court vacatur. So this means he just goes through and explains there was this issue, this venue issue, right, of where it was supposed to be filed. And so he goes through and explains it doesn't matter. That does not matter. What matters is that there was a court order. And even if venue was not in the right place, it still doesn't remove the authority of that court order. So that's what he's going through here. So I'm just kind of fast forwarding here a little bit. Sufficiently clear, reasonably specific, and unequivocal order. He goes in and explains. The defendants the whole time are saying, well, we weren't really sure what you meant, or you gave an oral order, rather than a written order, which I think is one of the absolute worst arguments here, because of course they give the orders all the time from the bench. I do want to pick up the second part of this particular argument just to make sure that we have the full scope of what his piece is. Okay, here we go. All right, I'm going to go ahead and pick up at this spot because I think this is an important piece to remember. Here we go. Insofar as INA cases are relevant, moreover, they demonstrate that at the time the TRO issued, the government understood removal to mean the exact opposite of what they do now, of what they claim. But don't take the court's word for it. Just listen to the argument the government made a mere 5 days before the events in question here. In a different case in this district with some of the same defendants and in a filing signed by some of the same lawyers signing defendants' show cause response, the government argued that removal under the INA is a term of art and that to effectuate a departure or removal, the alien must lawfully enter another country. And the fact that he is physically on foreign soil is not alone sufficient to establish that he has legally departed the U.S. Oh my gosh, I can't believe they would even write that down here. Defendants then do not show that removal carries a specific meaning that they urge under the Act, the Alien Enemies Act, for that reason, rather than a smattering of late 18th century dictionaries and an inconclusive fragment of the Act's text. The better, indeed, the obvious place to look for the meaning of removal in the court's written TRO is the hour-plus-long hearing that immediately preceded it. Ooh, this judge is so mad. He's citing the Young case. Or, here we go. Context for determining meaning of injunction includes objective circumstances surrounding the issuance of the order and audience to which it is addressed. Oh my gosh, this judge. Anyone paying attention to the hearing, as the government presumably was, would have known that the ultimate action plaintiffs sought to prevent through a TRO was not their mere transportation across the U.S. border, but instead their discharge from U.S. custody into a foreign country or into foreign hands. That's really the key piece here. They're not saying, well, let us go free. We didn't do anything. They're saying, we need to remain in U.S. custody. You can't put us in another country's custody. That's outside of the realm of what is appropriate for due process in constitutional law. Even for non-citizens. Non-citizens still do have some basic pieces here that are allowed. So let me fast forward again here. So that was his basic argument. And then we have the violation, which I do want to go into again because he's making this determination. We have I missed the flag. Sorry. I missed the flag. Whoever was flagging me there. I apologize. So we've got the summary here, and then I will just jump down to the violation. The second element of contempt requires that sufficiently clear and specific order was in fact violated. Defendants do not dispute that if the order indeed proscribed transferring class members out of the U.S. custody, they plainly violated it hours after it issued. Rather than mount any factual defense, they rely on post hoc legal arguments to attack the validity of the order itself. These positions are without merit, but more important, they're not even available to the defendants. As previously explained, per the collateral bar rule, what matters is whether they violated the terms of the order, not whether the order itself was legally valid. Now, the next piece, this is our constitutional crisis that everyone's talking about. And the judge just sets it out. He's not even pulling any punches here. We have a separation of powers issue going on. Defendants first claim that even if the TRO used the term removal to describe a legal departure and thereby did enjoin class members' transfer into foreign custody, it did not prohibit, indeed could not prohibit, defendants from making such a transfer if the class members were already outside the United States at the time of the order. That argument sails wide of the mark. Underpinning their claim is a sweeping assertion. They contend that once the class members exited U.S. airspace, defendants' authority over them flowed solely from the president's Article 2 powers, not from the congressional grant of immigration authority invoked by the proclamation. In their view, from Elval to the U.S. border, defendants transported class members pursuant to the act. Upon exiting U.S. airspace, however, the act fell away and the defendants continued under only the president's Article 2 powers. From that bold premise, defendants urged 2 points. They first posit that because it only enjoined removals effectuated pursuant to the proclamation, the TRO, by its terms, did not reach conduct outside the United States territory taken pursuant to Article 2. Even were the premise solid, which it is not, this is simply another argument about how the TRO should be construed based on its language. But we have already been down this path. The TRO should be understood in light of the circumstances in which it was issued, not given a belated gloss of virtue by sweeping separation of powers theories raised for the first time in briefing. To reiterate again, the relevant context here demonstrates that the order clearly and specifically prohibited defendants from transferring any class member into Salvadoran prison, even, in fact, especially if they had already been flown outside of the United States. So this judge is just laying it down here. To the degree the defendants' objection does not concern the order's interpretation, it melds into their secondary argument. Even if the court's order prohibited or purported to prohibit transferring custody of the class members already outside the United States, the court lacked the constitutional power to enjoin such transfers. Right? Executive branch's handling of class members abroad was beyond the court's authority to adjudicate. This position does not persuade. First, and most important, the collateral bar rule stops it in its tracks. Even if defendants' theory of Article 2 power were sound, it would not help them in this contempt inquiry. The argument at bottom is an attack on the legal validity of the TRO. By restraining their conduct, defendants say the order infringed on the president's Article 2 powers and thus violated the Constitution. Extraterritorial exercise of President's Article 2 authority presents a non-reviewable political question. But, as explained above, defendants cannot defend contempt charges by asserting the unconstitutionality of the injunction. Sorry, tea time, everybody. This is citing case law here. If defendants believed, correctly or not, that the order encroached upon the president's Article 2 powers, they had 2 options. They could seek judicial review of the injunction but not disobey it, or they could disobey it but forfeit any right to raise their legal argument as a defense against criminal contempt charges. They chose the latter course, even if their Article 2 argument could be construed as something other than a barred collateral attack on the legal soundness of the orders, it would still come up short. There is no merit to their contention that outside the U.S. airspace, defendants somehow operated solely under the president's commander-in-chief powers, not the Alien Enemies Act. The Constitution gives Congress plenary authority over immigration. So any discretion over the admission and exclusion of aliens possessed by the executive extends only as far as the statutory authority conferred by Congress and may not transgress constitutional limitations. Since the Act's passage, moreover, an unbroken line of cases has considered the disposition of alien enemies during a state of war to be within Congress's constitutional ambit, not the president. And then he's citing further case law here. Although defendants offer certain soundbite ready assertions, and then he's citing that, declaring president's plenary authority derived from Article 2 and the mandate of the electorate to remove from the homeland designated T's. They cite no legal authority that defendants here operated pursuant to the presidential power, preclusive of both congressional and judicial power. Such an extraordinary claim must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system. And he's citing the Youngstown case. Now, this is the landmark case regarding separation of powers and presidential power here. Yet across multiple filings, they muster not a single case in direct support of the proposition that when the government carries out deportations pursuant to a grant of a statutory authority, that authority is necessarily eclipsed by the executive's exclusive constitutional prerogative when deportees leave the U.S. territory. All right. And I'm going to go ahead and skip forward. So he does go further into more of that explanation, and this is really important. I'm not going to be able to read through all of it tonight. It's just too much, but I think it's really good that the judge is just sitting here and saying, look, you got to follow the rules. You didn't give us any evidence to support anything that you're saying. Meanwhile, we have tons of case law supporting that. Also, the judge goes into, well, this was clearly willful. You knew what you were doing. You knew how you were doing it. So then the next big piece to talk about, everyone, what happens next, right? That's the very big piece. So this case you can pull up online, and then the most recent order in here is document 81. And you can, yes, thank you. Thank you, VC, exactly right. This is document 81. You can pull it and read it yourself. Here. So next steps. So now what? This judge, I was like, I've just about had it. Let me check my battery. Okay, I'm okay. The court last details the next steps that these proceedings may take. First, before initiating any criminal contempt proceedings, courts typically allow the contempt. Sorry, everyone, I'm struggling. Contumacious. The bad people party, the wrongdoers, an opportunity to purge its contempt. That is, to remedy its violation by voluntarily obeying the court order. Oh my goodness. I'm sorry, I'm cracking myself up here. Citing the Yates case, a court should first apply coercive remedies in an effort to persuade a party to obey its orders, and only make use of more drastic criminal sanctions when the disobedience continues. And then citing further, the district judge normally will preface a contempt citation with an order directing either compliance with the subpoena or a showing of an excuse for noncompliance. The most obvious way for defendants to do so here is by asserting custody of the individuals who were removed in violation of the court's class-wide TRO, so that they might avail themselves of their right to challenge their removability through a habeas proceeding. So did you catch that, everybody? He's saying one of the ways that you can cure this contempt is by taking them back into U.S. custody, the people that have been taken there, all right? Per the terms of the TRO, the government would not need to release any of those individuals, nor would it need to transport them back to the homeland. The court will also give defendants an opportunity to propose other methods of coming into compliance, which the court will evaluate. In the event the defendants do not choose to purge their contempt, the court will proceed to identify the individuals responsible for the contemptuous conduct by determining whose specific act or omission caused the noncompliance. At the suggestion of the government in the last hearing, the court will begin by requiring declarations. Should those be unsatisfactory, the court will proceed either to hearings with live witness testimony under oath or to depositions conducted by plaintiffs suggesting declarations, depositions, and hearings. The next step would be for the court, pursuant to the federal rules of criminal procedure, to request that the contempt be prosecuted by an attorney for the government. All right, so here's our next step. If the government declines or the interest of justice requires, the court will appoint another attorney to prosecute the contempt. This is what I've been talking about, everyone. All right. So they're like, oh, the Department of Justice, we don't want to do it, blah, blah, blah. The court can appoint an attorney. a special counsel to take the case. Finally, a note on defendants' invocation of the state secrets privilege, which permits the government to prevent disclosure of information when that disclosure would harm national security interests. They invoke the privilege as a ground, not for providing certain details related to the movement of flights and class members before and after this court's TRO. Sharing such details, they assert, could make foreign countries less likely to collaborate with the U.S. I don't think that's why. In the future, and would disclose means used to thwart alien enemies, allowing them to evade capture and risking the security of removal personnel. Defendants also add that there is also no need for information in this case, as the court, quote, has all the facts it needs to address the compliance issues. You don't say that to a court. They don't like it when you say that. Judicial review of state secrets invocation is circumscribed, but not non-existent. The government's claim is to be afforded the utmost deference, and the court must evaluate whether there is a reasonable danger that compulsion of the evidence will expose military matters, which, in the interest of national security, should not be divulged, citing case law here. The court is exceedingly doubtful that the privilege applies here. It is not inquiring into the diplomatic agreements that facilitated the flights, nor the operational specifics of how defendants apprehended and transported the class members. Instead, the court is simply seeking to confirm times and numbers, how many passengers the two flights carried, whether they were all deported pursuant to the proclamation, and when they were transferred out of U.S. custody. The court is skeptical that such information rises to the level of a state secret. As noted, the government has widely publicized details of the flights through social media and official announcements here, thereby revealing snippets of the information the court seeks. Seats and raising doubts that such information would jeopardize future diplomatic engagements or operational security. So we've just learned that if you want to claim that your information's too private for a judge, don't put it on your social media, all right? That's what we've learned here. Defendants, moreover, have still not asserted that the information is even classified, and they have identified no case in which unclassified material was nonetheless protected by the privilege. Nor is the court yet persuaded that even if publicly disclosing the information might harm state secrets, sharing it only ex parte with a federal court would do the same. At this point in the contempt inquiry, however, the information at issue is not necessary to proceed. Sorry, everyone, I got to do tea break here. So the court will not resolve whether the invocation is warranted. Quoting the Reynolds case, necessity of information determines how far the court could probe in satisfying itself that the occasion for invoking the privilege is appropriate. But if the information turns out to be necessary later in these proceedings, the court may revisit the invocation. Conclusion. All right, here we go. For the foregoing reasons, the court will find probable cause that the defendant's actions constitute contempt. It will provide them an opportunity to purge such contempt. If they opt not to do so, the court will proceed to identify the contemners and refer the matter for prosecution. Separate order so stating will issue this day. Sorry. Oh my gosh, I'm sorry everybody, my voice is going. Drink some tea. Sorry. Okay, I think I'm going to have to go ahead and go at this point, everybody. I apologize. I will be back to do a Q&A on all of this. I will have this posted on my YouTube as well. I recommend going and following me over on my YouTube in case the app goes down. Thank you for coming by, everybody. I'll see you all very soon.